Hello, everybody. Welcome to today's webinar. My name is Liz Gallagher, and I'm a paralegal here at Lyles Parker. Today's webinar, hosted by the Texas Association for Home Care and Hospice, is entitled Responding to a Potential Privacy or Security Breach, Internal and External Strategies. Today's presenters are attorneys here at Lyles Parker. Michael Cook and Regina Marano are today's presenters. And I guess without further ado, I'll go ahead and pass it over to them, and they can give you a little more information.
Great. Liz, can you move the slide up next to the next slide?
Will do.
Hi. Welcome everybody to today. My name is Michael Cook. I'm a partner and co-chair of Lyles Parker's Healthcare Group, and have been representing healthcare-related clients full-time for over 40 years. And before that, at the start of my career, I represented the federal regulators of the Medicare and Medicaid programs as an attorney for the United States Department of Health and Human Services. During this period, I've represented virtually every segment of the healthcare industry with a strong emphasis on subacute providers such as home health, home care and hospice, on regulatory compliance, investigations, business and policy issues, frequently before state and federal regulators. I also, apropos to this topic, was a co-chair of a multi-office, multi-practice group HIPAA task force back in around 2001, right after the HIPAA regs were implemented at a prior law firm, and like many people have addressed security and privacy issues. I'm also a fellow of the American Health Law Association. I'm chair of the board that oversees Virginia's Medicaid program as an appointee of Governors McAuliffe and Northam, and I have served on healthcare transition teams for 3 Virginia governors-elect. Regina, you wanted to introduce yourself?
Yes, thank you, Michael, and good afternoon, everyone, and thank you so much for joining us today for the webinar. My name is Regina Marano. I'm also an attorney of counsel with Lyles Parker. I'm exclusively a healthcare regulatory attorney with a concentration in compliance. I've been practicing law for 27 years now, in both the private sector and the public sector. I actually started my healthcare career prior to law school as a Jesuit volunteer, which is similar to the Peace Corps, but sponsored by the Jesuit order here in the United States. And I worked in Baltimore with the Healthcare for the Homeless program there. And since that time, I've worked with many of the leading healthcare and regulatory organizations really throughout the country. I did have an opportunity to serve as a special counsel and an ethics officer during the administration of New York's Governor George Pataki. I was a legal and legislative counsel to the chairman of the Workers' Compensation Board. And in fact, when the HIPAA regulations took effect, I was working as special counsel to the chairman and had the opportunity to assess for the state of New York the impact of those regulations on workers' compensation records in particular. I've also worked for Academic Medical Center, University of Maryland, a number of other healthcare organizations, and have been focusing the last 10 years or so both in-house and as an outside legal counsel to laboratory and managed care organizations. I did work also in New York State for one of the largest home care organizations there that was owned by Blue Cross Blue Shield in the upstate New York region. So I'm happy to sort of look back on that experience as we talk today with your organization as well. So I'm just delighted to be here with you. Michael is going to take the first half of the presentation in terms of the agenda. What we have organized for you today is an initial section of the presentation, which focuses on the history, the implementation, and the amendments, essentially outlining, Michael will outline for you the whole regulatory framework of HIPAA. And then we're going to talk about both privacy and security breaches, penalties, and hopefully some helpful considerations for you as you think about and you reassess your own sort of readiness to handle both privacy and security HIPAA considerations at your own organizations, and some advice that we hope will be practical for you as takeaway today. So with that, Michael, I'll turn it back to you for the first half of the agenda.
And we'll be commenting on each other's slides perhaps as we go along as well. We're really fortunate to have someone like Regina with us. As she said, she's got a wealth of experience as in-house privacy, security and compliance officer, as well as in other aspects. At any rate, I'm going to start out by providing you some necessary background on the rules. At the outset, I'd like to mention that we'll be focusing primarily on the federal legislation and regulations in the area. However, while federal regulation generally controls and preempts state legislation, where the state legislation is more restrictive, it takes precedence over the federal HIPAA rules, and Texas has its own privacy law. So as an example, Texas has a privacy law that's more restrictive than the federal law in what it considers to be a covered entity. For the feds, as we're going to discuss shortly, it covers any entity that transmits information in electronic form for a standard transaction such as billing, whereas in Texas, a covered entity is not limited to electronic transactions. So for example, it would cover entities that transmit paper bills through the mail, although obviously at this point in our lives, most healthcare organizations are covered under the federal rules as well. Also, a Texas Attorney General's opinion requires data breaches to be reported to the Attorney General's office, as well as the federal rules requiring federal sources that require federal reporting that Regina is going to talk about later. So while we will be discussing the federal provisions on security and privacy, you should keep in mind that there are state requirements as well with which you need to be familiar. And as the slide states, the best way to think of this is that HIPAA serves as a floor and not necessarily a ceiling. Can we go to the next slide if we could, Liz? HIPAA privacy and security have been around since the 1990s. I think I had hair when they were when it was first enacted, so you know how long ago that was. They were basically part of the Health Insurance and Portability and Accountability Act of 1996. And to give you some context, when it was first enacted, while the Act has numerous provisions and covers a wide variety of areas, including fraud and abuse issues, the principal area of discussion was health insurance protections for individuals and the portability of healthcare plans. However, also tucked into the Act was a section that addressed privacy and security protections for healthcare information. And at the time, most of us who were practicing healthcare law full-time gave that part very little focus. However, all that changed in December of 2000 when HHS, Health and Human Services, published the first privacy rules under HIPAA. For those of you who are old enough to have been working in healthcare at the time, you'll remember the rules were extremely voluminous, and on top of that, they were so complex that the Office of Civil Rights, the component of HHS that was given primary responsibility for implementation of the rule, issued numerous FAQs on their interpretation, and we used to refer to it at times as almost governing by FAQs, or frequently asked questions. In the legal field, those of us who were in large firms remember the development of multi-departmental HIPAA task forces to understand the various tentacles of the rules. We were on conference speaking circuits with security experts and privacy advocates, and it took on a life of its own. I even remember working on the healthcare, working the healthcare with the healthcare department of a large major national firm that I was with at the time, developing a complex provision by provision preemption analysis that compared Texas and federal law for a major trade association, and similar compendiums were being drafted throughout the country. This slide simply sets out the various timelines and statutory and regulatory changes, with the last major change in regulations having occurred back in 2013. And they now have become a standard way of doing business in the industry. Liz, can we go to the next slide?
Michael?
Sure.
Just to amplify something that you were focusing on here, the frequently asked questions, that is really still today a terrific and very informative resource that folks should keep in mind when they do have questions, even around very specific scenarios. So it's good to remember they're still out there and they're still updated.
Absolutely. Thanks, Regina. So now we're going to get to the meat of HIPAA. First of all, who's covered under HIPAA? Covered entity is generally a health plan, a healthcare clearinghouse, or a healthcare provider that transmits any health information in electronic form in connection with a standard transaction. Merely using email is not sufficient to make you a covered entity, but rather it must be in connection with a standard transaction such as billing or transmission of medical records. And there are also entities known as hybrid entities, which are entities that have business activities that include both covered and non-covered functions. And as an example, a large paper box company may also provide health insurance through a self-insured plan for its employees, and the latter activity would be covered by HIPAA and privacy. And finally, where a covered entity engages a business associate to carry out its healthcare activities and functions, the security and privacy rules of HIPAA also apply to these entities. I'm sure that each home health agency or hospice on this call has developed a business associate or even a subcontractor business associate contract that it requires its vendors who handle protected health information to sign. The key point to remember for these agreements is that the Health Information Technology for Economic and Clinical Health Act, we call it, or the HITECH Act, in 2009, which is principally remembered for requiring interoperability and providing grants for certain providers for that, also made business associates liable for compliance with certain requirements of HIPAA. And this in turn has raised a number of issues when you're dealing with a business associate agreement, such as trying to negotiate indemnification clauses for breaches for which the covered entity is principally liable, but that are caused by the business associate or even a subcontractor business associate. Just as an example, several years ago, actually a number of years ago, I was working with a client that was transmitting medical record information through and its website, which was hosted elsewhere. And it was like pulling teeth because the website didn't collect a lot of money, as you can imagine, for its use. And yet, if there was a breach that was its fault, it could be subject, as could the covered entity, for huge fines. And there were major arguments back and forth over the business associate agreement of all things, and the indemnity issue especially. We finally solved it by having the client had very strong internal back office folks, and they were given access to take a look at it, but it was not an easy negotiation. Next slide, if you could, Liz. This slide discusses some of the considerations for home health and hospice providers that are small and mid-sized. And as the slide states, the law allows for scalability, which can keep some compliance expenses down for these entities. However, there's some real challenges in these organizations, such as dedicating necessary space to keep unauthorized persons from areas where PHI is accessible. And keep in mind that, as the slide states, these providers still have to comply with privacy rules, as I'm sure you're all aware. One of the big issues is unencrypted laptops, presenting probably the most common risk for handling PHI in home health agencies and hospices. And as you've all had, I'm sure, drummed into you, the story of this laptop stolen from nurses or coworkers, along with the need to ensure that the laptops are encrypted. And our own firm privacy officer has actually counseled us to require laptops stored in our home to be locked to our desks at home, or put in locked home offices when we're not attending to them. And there's an example of a case where a large healthcare provider retained an outside contractor to conduct quality improvement audits of their medical care. And the quality improvement auditor shared the information with a subcontractor, basically records of almost 10,000 patients, which the subcontractor stored in an unencrypted laptop. The laptop was stolen as part of a home robbery and had not been recovered as of early 2022. And as an aside, if the provider is assessed a fine by OCR, the contractor and subcontractor likely will be sued, especially if there's an indemnity clause in the BAAs that they signed. And also, the contractor can be fined by the government, but the most important thing to remember is that the provider who hired the business associate as a covered entity is ultimately responsible for any breach. And Regina is going to go into that further with you in the portion she's talking about. Also, the rule doesn't cover de-identified information, where all 18 identifiers that are listed have been removed. However, the 18th is really a catch-all that states any other unique identifying number, characteristic, or code. And there's an example where a physician who worked in an emergency room was cited for a HIPAA violation when he posted information on social media regarding a recent trauma patient that didn't cite any of the specific 17 traditional pieces of information. But the facts of the case were unique enough for members of the community to readily identify the patient, and that was considered a breach. The employing hospital fired the doc, who was also reprimanded by the state medical board. So while scalability does not remove the requirements for complying with the privacy rule, an example of where scalability would apply to a small provider is potentially to allow for the appointment of a privacy officer who has other officer clinical duties. But the security rule also provides the covered entities have some flexibility in that they can choose security measures that allow the covered entity to reasonably and appropriately implement the requirements. The scalability measure factors are listed at the bottom. These are what you have to consider as a small entity or mid-sized entity when you're making adjustments to security factors and what the government will look at. Liz, can we go to the next slide? It's also critical that organizations remember a critical premise when requesting, reviewing, handling, or disclosing of PHI, namely, as you see on the slide, that organizations may only release PHI as explicitly permitted by the rule. One second here. By the rule or with prior written consent of the individual who is the subject of the records. Moreover, when access is permitted or required, the minimum necessary standard applies. And the minimum necessary standard requires that when a covered entity accesses or discloses PHI or requests health information from another covered entity, the requesting entity or disclosing entity has to make reasonable efforts to limit the PHI use or disclosure to that which is reasonably necessary to accomplish the intended purpose. Two examples that we always use is whether the billing clerk really needs to access a patient's entire medical record, or does the janitor really need to access to that record when cleaning an office, which may contain records. The slide also lists, oh, can we go to the next slide, Liz? This slide lists the basic rights of patients, namely to have a privacy notice that we've all drafted and we all receive all the time, and I suspect no one reads them, but they're required to be provided, to know when and to whom there's been a disclosure, to request restrictions on how the provider communicates information, especially to health plans when the patient has paid for those services out of pocket. Less reason for the health plan to have to know specifics if the patient should request that that information not be provided. Patients got a right to make copies of privacy notices, to access records except in limited instances, and you can charge a reasonable amount for copying records, but as we always ask, do you really want to do that? They also have the right to amend his or her file. However, they can't alter the doc's records. They can just add their own comments, and to complain of violations. Covered entities must explicitly plan for tracking cost disclosures on a regular basis, and they must keep a log of all disclosures of patient information. They also must plan for patient communications. In other words, they have to ask the patient whether the patient prefers phone calls, whether it's permissible to leave a voicemail, or use email, and they've got to adhere to the patient's preference. Can we go to the next slide, Liz, if we could?
Michael, just a note before we leave that slide regarding patient access and copies too, just a sort of a practical note. In the last couple of years, I did have some interaction with OCR, the Office of Civil Rights, and they were doing, in a particular region, they were doing some spot checking around the extent to which requests were being made by patients for their records. And of course, this all is around the advent of electronic medical records. And they were checking as to whether, at least in this particular region, whether or not the records were being charged for. And they were putting some pretty heavy pressure on organizations not to charge. And the theory was, if you could download something to a thumb drive and you could send it that way, then you shouldn't be charging 50, 75 cents or $1 per page. And so there was a real push to do that. And I just think that's a good consideration. If you're sending something electronically, to be careful about not exceeding the actual cost of what that charge is. And in particular, with my charts available today, the electronic access by patients, I just want to caution our folks to be careful around charging for things that are not really an expense.
That's a great point. That's a great point, Regina. And frankly, the cases that we're seeing out there more than any are cases of access to records themselves, just patient access to records. But as you pointed out, Regina, most of us who go to docs these days have access to to medical records, to electronic medical records through charts like MyChart and other electronic modalities. This slide talks about notes that there's a tiered penalty structure for violations of breaches. And starting with 2009, really, and HITECH, CMS is required to base its penalty determinations on the nature and extent of the violation, whether the violation has been corrected, knowledge, the range of CMPs depends on whether an individual is a first-time or repeat violator. one of the most important things you can have, you have to have a privacy and compliance plan, and they need to be effective compliance and privacy plans. In other words, they can't just be something that's stuck up, pre-printed and stuck up on in your bookcase and never opened. If you've got if there's a violation, that's going to be one of the early things that you're going to be asked about. Also, like covered entities, business associates are now may be liable for civil money penalties, and OCR can in fact go against business associates, but again, the covered entity is ultimately liable for any breach and penalties. Liz, can we go to the next slide if we could? Basically, this just talks about the penalties for breaches, and it shows you the sliding scale. And you can see, for example, the difference between the minimum penalty where the offender did not know, and even by exercising reasonable diligence wouldn't have known, and that's 100. The penalty there is $100 per violation, whereas the most costly penalty is $50,000 for violation where it was due to willful neglect and was not corrected. And as you can see here, the maximum amount per year for the minimum minimum offense is $25,000 a year, whereas the maximum for willful neglect is $1.5 million a year. So it's worth noting that there can be real penalties that are assessed on you. Can we? And also states, there is no private right of action under the federal HIPAA rule, but states have their own fines, and some states also have private statutes that provide for private rights of action under state law. Again, another reason for being familiar with your state law. Can we go to the next slide, Liz, if we could? And this slide just talks about the factors to be considered when in determining the amount of the civil penalty, and these tend to be negotiated out as well with HHS. But there are some mitigating factors as well: the nature of the violation in light of the purposes of the rule, the circumstances, including the consequences of the violation, the degree of culpability of the entity, any history of prior compliance issues with the administrative simplification provisions, the financial condition of the covered entity, and the catch-all, any other matter that justice may require to be considered. And if we can move to the next, Liz, if we could. These are the primary risk areas for failure to comply. Give me 1 second here. Hold on. Yeah. These are the primary risk areas. Impermissible uses and disclosures of PHI, obviously, and you can have criminal prosecutions. For example, where hospital employees have used PHI for personal gain, and cases where a physician gave access to third parties for marketing purposes. Lack of safeguards of PHI. Have you done your annual HIPAA high-tech security risk analysis? You've got to do that every year, and you want to make sure that you document that carefully. I mentioned the lack of patient access to PHI. So far, as the slide says, OCR has resolved 25 of these cases since their initiative first began. And Regina gave you some more good suggestions with respect to access and charging. And finally, the use or disclosure of more than a minimum necessary PHI. Now, just to give you some stats, though, since the initiation of the time that the privacy rule went into effect through November of 2021, the OCR website lists the following numbers. HIPAA complaints received since 2003, 283,429. Percentage of cases resolved to date, 96%. Cases in which corrective action was required, 29,285 cases. Cases in which CMPs were imposed, only 106, but the amount of the CMPs imposed was $131,392,632. So they're significant. The amounts are significant. Regina, do you say you have something to add on 12?
Yeah, I was just going to transition from 12 to 13 because it's moving from sort of the privacy breach aspect to the security breach aspect.
Great.
So, yeah. Okay.
It's all yours.
Okay. Thanks so much, Michael. That was wonderful. You know, based on that sort of foundation, the history and the structure of the regulatory framework around HIPAA, we wanted to talk a little bit in depth around what constitutes a breach, sort of walk you through what breaches might look like, what the risks are there, essentially what are you supposed to do, how do you recognize them, and what do you do afterward. So I'm on slide 13, and I want to talk here on this slide about, first of all, what is a breach and what is not a breach. So if we take the technical term from the regulation itself, you know, a breach is the acquisition, access, use, or disclosure of PHI in a manner that's not permitted and which compromises the security or the privacy of the PHI. So let's unpack that a little bit. That's the technical definition of what a breach is. So that means, did somebody actually acquire PHI? Did they look at it, actually view it? Did they somehow use PHI? Or were they given PHI, for example, permissibly in the context of their job, but then they impermissibly disclosed it outside of their job? So that would be, all of that would be, you know, the obtaining or the disclosure or the use of PHI. That would be, that would put you at risk of violation. And is it done then in a manner that compromises the security or the privacy? So I'll get in a minute to essentially a four-part analysis that you have to do, that we all have to do whenever we think we have a breach. And then from that analysis, we determine whether there actually has been a breach. So we'll get to that in a moment. And it's possible, just as a side note, an important side note, it's possible to have a breach that meets this definition, but the breach would not be reportable or actionable if you get favorable responses when you do this risk assessment under HIPAA. So a few words, though, about what is not a breach. So again, right under the regulation, we have these two categories of things that are not breaches, and that's unintentional access or acquisition or use of PHI by someone in your workforce or someone under the authority of you as a covered entity or a business associate, if they do it in good faith and it doesn't result in any further use or disclosure. So that could be something as simple and unfortunately as common as perhaps you know, sending a fax to the wrong fax machine, right? That could be unintentional. That could be someone who's authorized to send a fax out, but if it goes to the wrong entity, it could be a breach. But you can sort of protect yourself, or you can be protected if that goes to, depending on who that goes to. So if it goes to the gas station down the street, you know, you're going to have an issue. But if it goes to one doctor versus another doctor who's also a covered entity, not so much of a problem. And then something I think that is an issue or a consideration for really any healthcare organization, but in home care and home health, it has its own unique issues, and that's the inadvertent disclosure. So I think we're all really used to the issue. If you're old enough, I think you'll remember the difference between, going to the doctor 20 years ago versus going to the doctor today, right? 20 years ago, you'd walk in, you'd stand in line perhaps to check in. There'd be someone literally right over your shoulder. People would be asking you, what are you here for? And you're talking about, why are you here? And they're calling you from, into the treatment area by your first and last name. And, there's all kinds of PHI just exploding in that environment. And, today that's a much different environment because we're trying to prevent what we call inadvertent disclosures. And inadvertent disclosures are not a violation, right? So if you are sitting in the waiting room of a doctor's office, or you are in the home treating a patient in the home health environment, and they have a neighbor over, and that neighbor is sitting in the room, or a family member is sitting in the room with the permission of the patient, and you're talking to that patient openly about their health condition, or you're doing PT with that person, or you're doing an OT assessment, or you're a nurse treating them right in the home there. If there's a person there with the permission of that patient, yes, they're going to hear PHI. They're not an authorized sort of receiver of that PHI, but there is no violation if that person is sitting there with the consent and the permission of the patient. So we talk about inadvertent disclosures. We talk about things that happen in the treatment environment where something is overheard in a hallway, or something is overheard in a waiting room, or something is overheard in the home treatment area. It's mostly, I like to think of it as overhearing. So, so those are two sort of statutory exceptions and statutory areas where the HIPAA says these are not so much a problem. We still have an obligation to protect against that as much as we can, but these are not really viewed as breaches. I do want to give some examples of what is a breach. We can probably jump to the next slide here. What is and what is not a breach. I want to give you some examples of real life cases. Some of these are my cases that I've been involved in, and some of these are just well-known cases that we've read about sort of in the field here. As Michael was talking about earlier, the loss of a laptop or even a desktop that contains unsecured PHI, that's a breach. And laptops are just, can sometimes be considered almost the epicenter of these breaches. They get stolen, they get lost. Somebody runs through an airport and leaves it behind. Car is broken into. Any number of ways that a laptop could be lost or stolen. And the key there is unsecured though, right? So if you, as Michael said, if you're locking up your laptop, if you're always bringing it, if your teams are always bringing their laptops into the house, right? Because your teams are out in the field all day, every day. Then they are coming home, they're working on their notes at home. And you want to keep an eye on the phones as well. You want to have rules in your HIPAA policies around how they handle both the laptops, the tablets, and the phones today. Essentially, that they are always they're never unattended, and they are never left in a car, and they're always locked up, and they're encrypted. And encrypted is very, very important because encryption can save you from really enormous headache, expense, and unfortunately it can avoid enormous harm to your patients if you simply ensure that those devices are encrypted at all times. But other examples, careless or thoughtless or unthoughtful use of email, where maybe an email, maybe it's a marketing email or a reminder email that's going out to a bunch of patients or all the patients, and the person sending the email forgets to blind copy everybody and ends up sending an email with where each patient is seeing the other patient's name and email address. That's a real live example. Improperly disposing of paper records. This is a real life example that I had dealt with a particular client. There was a billing department employee who, instead of taking her discarded papers directly to the secure destruct bin, right, in an office, would leave them in a box under her desk. And then when she had a certain amount sort of piled up in that box, she would take them over to the secure destruct bin and throw them all in there at the same time. And unfortunately, one night, the cleaners came in and picked up that box and took it out as garbage, right? So that is potentially a HIPAA breach. And what happened in that case, and again, this is a real life example, what the organization did was they had staff from that particular hospital engage with the garbage hauler company. They reenacted exactly what happened. They did this quickly, like the very next day, reenacted exactly what happened. Ended up actually driving in the truck out to the dump to see where the paper had been dumped at the dump, and able to make an assessment.
Regina, you're going out a little bit on your
Volume.
Yes, much better.
Okay, good. Let me just make sure I'm lined up here. Okay, so anyway, the short and the long of it is that the organization was able to determine it wasn't a breach because they could see exactly where the garbage was dumped, and they could see the risk of harm, the risk of someone actually going in there and finding that those papers was slim to none. So that's just another example. But binders can get stolen out of vehicles. We have cases on that. Papers just being disposed of improperly. We have cases on that. Invoices or other documents just disappearing, right? We have cases on that, and we know, unfortunately, we have cases where we've seen that folks have, employees have actually taken or removed information and used that either for identity theft or other purposes. So if something is missing and you can't account for it, you have to think of that as a breach. And another just odd example, just quickly, I had a case where an employee in a hospital, when a code would go off, if you're in a hospital, you're probably familiar, a code will be called to a particular room number and a particular bed number. And this employee was, every time a code was called, would hear the code, would hear the location, and would go into the electronic medical record and essentially, just out of nosiness, look at what was going on with that particular patient. And that was caught, fortunately, it was caught by the hospital itself, because they were doing what we all should be doing, which are routine access audits, and essentially randomly checking, X number of patient or X number of employees EMR accounts to see who are they looking at, and assessing whether there's a true business reason to be looking at that information. So so those are examples of breaches. But I think what more and more what we're familiar with when we talk about breach are the ransomware and the hackers. And I think we used to think, even up to a few years ago, we used to think, Target gets hacked and large banks get hacked and UCLA Medical Center might get hacked, but maybe our smaller hospital or doctor's office or home health agency isn't necessarily going to have to deal with a ransomware attack. And unfortunately, again, from experience, what we're seeing are smaller organizations who don't necessarily have the highest level of HIPAA security in place, are getting hacked, are getting ransomware demands, and in many cases are paying those, even with Bitcoin and untraceable assets. So it's a problem, unfortunately, for all of us, and not for just for the the larger organizations. So that's a little bit of background on what a breach is. And I just wanted to touch a little bit further on the breach notification requirements. So I think we want to skip to the next slide.
Yeah, Regina, if I could just make one quick comment on that. You will find probably, I know our law firm, for example, encrypts and has clients encrypt, either encrypt or send to a Dropbox where we encrypt it, any potential PHI. It is not that hard to do. You have to be conscious of it at all times. But we do a lot of audits. We do a lot of OIG production and DOJ production, document productions. And you have to be, and you just have to be extremely, extremely careful that that anything you transmit is of that nature is done in an encrypted fashion. You can put them on disks if you need to. We can encrypt them. We sometimes encrypt and send by email. It depends on the investigator and the auditors, but you really want to focus. It's not that hard to encrypt, but it is a pain in the butt, and you got to make sure you're doing it.
Right. But I think that's so important. It's probably the single most important thing that we can do to guard against breach, right? Because if that data is encrypted and it goes missing or it's accessed, it can't be accessed. So that's super important. And one sort of easy mistake I think that healthcare organizations can make along these lines, and I've seen this happen as well. A patient may email a provider, right, just on their Gmail or their Yahoo account, and the provider, without thinking, might respond, right, and without encrypting. So that's why the encryption is important, and the MyChart, the sort of online, very controlled environment, is the best way to communicate with patients. And don't respond to a Gmail. So, okay. So there's a little bit here about affirmative defenses. I don't really want to spend too much time on this because honestly, I don't want you to lean on this too heavily. If you're in a position where you're defending, you've done the analysis and you've unfortunately determined that you've had a breach. I don't want you to have to be in that position where you're defending that you didn't know, or that you have to prove that you exercised reasonable due diligence, and still the breach occurred, and still you were not aware of it within a reasonable time frame. I don't want you to rely on the fact that yes, there are affirmative defenses, but let's really focus on not getting to that point. And I think that's what I would emphasize for this particular slide. And then move on to the next. So these are the federal breach notification requirements. And I'm just going to give you a word or two.
Regina, you're going out again.
Okay. I turned sideways, so I'm going to not do that again. Okay. So in terms of the federal breach requirements, if you do in fact have a breach, you do have to provide notice to the impacted individuals no more than 60 days out. And not only that, you do have to, if more than 10 folks are affected, you have to notify the secretary of HHS. There, not only that, but if you have small breaches, even if you have one breach, where patient received a bill belonging to another patient, you have to track those during the year, and you have to report those as well, either within report within 30 days, or you can wait till the end of the year and you can report them. This is all online, in case you're not familiar, but you can report them online, and you have to do it, I believe, by the end of March. So if you haven't done your reporting for 2021, you do still have a couple of weeks to pull that together and get that submitted to OCR, but they do have to be reported ultimately, even if you don't crack that threshold of 10 or 500, patients affected. But essentially, if there's a breach, there's going to be a notification requirement. You're going to have to include a brief description of what happened, when it happened, when you discovered it, what type of PHI was involved, what the patients can do to protect themselves, what you as the covered entity are doing to investigate or have already done to investigate or mitigate against loss in that case, to protect against further breaches, and then contact information if there are further questions. It's good to have basically a form letter ready to go. I don't think I'm telling you something you don't know when I say that virtually every entity is going to have some kind of breach throughout the year, whether it's large or small. It's good to have a letter ready to go. And there is some language that HHS and OCR prefer to see, particularly around steps that patients should take to protect themselves. There are some links to other resources that are going to include government resources where their concern or further questions could be reported. So as I said, have a good form that are sort of ready so that you can save time in the event that this happens to you. So I would we have just a few more slides, and I'm going to get those covered before we run out of time.
Regina, and I'll be very quick, but Regina, Texas has its own reporting requirements as well, with shorter time periods, I believe, and to the Attorney General as well. General, and I believe there are online notices for that as well, forms for that as well.
Yeah.
Regina, you're going out again.
My goodness. Okay. Texas did amend their law just last summer, and their law does include a notification requirement to the Attorney General, and it also includes a public sort of a roster of breaches. So that's something that folks out in their communities can access. Okay. So these are the basics, whether we're talking about federal government or whether we're talking about Texas. The feds and all the states have the same basic requirements, that you have to send a notice to the patient. There has to be a stamp on it, essentially. It has to go to the last known address. At the federal level, this applies to breaches of 10 or more. I think it's similar, actually, the numbers in Texas. If there are more than 500 people involved, then the Secretary of HHS has to be notified at the same time that the notification goes out to the patients. And if it's less than 500, as I was saying before, then you do have to keep a log of it, and you have to report it at some point, but you can wait until the end of the year, end of the calendar year. So next slide. There are actually, there is no, as Michael said, there's no individual right of action for a HIPAA breach or violation, but the government does have the ability to take a portion of any of the penalty money and pay that out according to some kind of a formula, and pay that out to folks who may have been harmed by a breach. So that's just something to keep in mind. It may drive the cost of penalties up if there's a larger, the scope of the violation is larger. Next slide. And then I did want to get into, I think, you can look at this slide as well. This talks about whether there are penalties and criminal sanctions. I think we just covered that, Liz. Maybe we can go to slide 20. I do want to encourage you to consider if you don't have it already, to consider securing cybersecurity insurance. It has been an absolute blessing in every case where I've assisted with the management of a breach. It's not cheap, but the coverage is generally quite amazing, covering not just getting a forensic expert, getting an attorney with specialized cyber experience. Sometimes they even pay for crisis counseling for your organization, and the cost of notification. So those are really, really expensive components of a breach. And cyber security insurance is really very good at covering a lot of those costs. Doesn't cover all those costs. And I think you want to look at, if you go this route, you want to look at, do your cost benefit analysis and determine, can you afford the kind of policy that you need that would have all the elements that you would need to cover in the event of a breach.
And on the other side of it, can you afford not to? Even as a law firm, we have cybersecurity insurance.
Exactly, Michael. I think, honestly, in this day and age, I don't know that any healthcare provider could go without it. So think about it seriously if you don't have that in place already. Two more sets of consideration here. So when or if you do have a breach or a fire drill around a breach, the first thing you want to do, you want to call your carrier, your cyber carrier, and you want to call your attorney, because there is not a lot of room for error, and because these are the two resources that are going to give you the best guidance and usher you through this and get you to the best possible result in terms of mitigating your exposure and in terms of protecting your patients. And they are the most important people. I really discourage you from trying to handle this on your own. And hopefully you all have really good, well-trained cyber experts, who you can get on the line quickly if you don't already have them in-house. But that's where you want to turn. And the role of the covered entity, your role is essentially to marshal your resources, marshal your information, and assist in making sure that any investigation is thorough and that all information is provided to your experts and the folks who are handling the investigation for you and with you, and to make sure that it's done under privilege as well. And then finally, after the fire drill, you always want to take that opportunity to assess, what did you learn? How did this happen? What did you learn? What can you fix in your systems? And always, always, always follow that up with enhancing your HIPAA security training. You really want to have cyber awareness embedded in your culture. You want people to have their antenna up with every email coming in around attachments. There's so much fraudulent email out there, people impersonating leadership in their own organizations, etc. And you do want to develop your own expertise in-house. You want to make sure that you're developing cyber and regulatory experts on your own teams as well. And that will really strengthen your position as a really well-guarded HIPAA, cyber, HIPAA privacy and security and well-secured organization. So that's the presentation. Michael, if you have final comments or we want to take questions.
Yeah, just one final comment, just echoing what Regina said. The most important thing you can do for a breach is not have one. And that means making sure that you've got a strong privacy plan and security plan, that you have a culture of recognizing those issues. And if you do have a problem, get in touch with your security experts and your counsel right away to help mitigate, to help guide you through mitigation process. the mitigation process. You can obviously call either Regina or myself or anyone at our firm if you've got questions or issues that arise here. And I'm sure many of you have your own counsel as well in that area. Are there any questions, Liz?
Yeah, we do have a couple questions. I'll go ahead and read them and then you guys can address them. So the first question I see, someone said, in quotes, to access records inspected and copy their records except in limited instances. I think that was spoken during the presentation. And they asked, can you give an example of the limited circumstances? Does that make sense?
Yeah. Michael, do you want me to take that one?
I'll kick that one to you because I have to go to the rule every time, and most of the and generally you're allowed. Oh, I suspect there may be some instances, for example, within either law enforcement or psychotherapy or something of that nature where the patient could be harmed. But Regina, why don't you grab that if I didn't hit everything?
Yeah, that is really, that's the primary example where we see this, where first of all, you have 30 days generally to decide whether or not you're going to turn those records over. And if there's a concern at all that turning the records over could cause harm to the patient, then you go to the treating provider and you ask the treating provider, do you think this could cause harm to the patient, or do you approve essentially disclosing it? And that's exactly right. And you see it a lot, sadly, in cases of suicide or attempted suicide or overdose or things like that.
Yep.
Okay. All right. Here's the next question. It's kind of lengthy, but I'll read it. Okay, so because Russia is a known offender in cyber warfare, is there now a more inherent risk of data breach because of the current situation with Russia and the US? And if so, why would healthcare information be attractive to cyber attack?
Okay.
That's
I think obviously I think concerns about any cyber about ransomware and cybersecurity are always concerning. Whether or not it is any worse with the current situation, I couldn't tell you, but given the prevalence already out there, just make sure that you have all of your all of your defenses up. Any other thoughts on that, Regina?
Yeah, I mean, I do. My concern, having worked in the
Regina, you're going out again.
Good gracious. My concern is, yes, I mean, we certainly heard the warnings that there could be a higher risk of cyber attack due to the situation with Russia. And why would they care about healthcare information? What they do is they don't just look at it and view it. They actually can seize up or lock down your system. And I've had cases like that where the hacker comes in and actually locks up the system so that it interferes with care. And patient records cannot be accessed. And care is disrupted. So it really does create an emergency in the healthcare environment, and that would be very disruptive, not just to the health system, but to the country.
And I think you had that risk before the incursion as well.
Correct.
Okay. We have one more question I see here. Does HIPAA coverage entity extend to our employees? If so, in what ways?
Okay.
I mean, if for example, are you talking about a healthcare? I mean, HIPAA requirements. If you have an employee, I'm not sure which way they're looking at. You're asking this.
Yeah, they don't specify. It's not specified in the question.
But if you have an employee, obviously, that employee, you are responsible for your employee's actions. The stolen laptop, for example. In terms of, does it apply to the privacy of your employees? As an example, again, the hybrid entity, you have a health plan. You have to protect the security and privacy of your employees in terms of their healthcare records. So you'll segregate that function out. Regina, you've probably been involved in setting those up. In fact, I would think.
Yeah, I think, Michael, I think your take on this is correct, that you want to distinguish between HIPAA apply. If you're a healthcare entity, you want to distinguish between the HIPAA rules that apply to your patients versus HIPAA protections do not apply to your employees or their information, but it would apply to your employee if they were a patient. And a lot of organizations do lock those records down, do give those records more protected status within their systems to further protect the employees, frankly, against other employees looking at their records.
Or even claims coming into your, HR department. If they get involved, you have to be very careful to segregate. And some companies, I know when it first came in, for example, some companies would segregate an employee for that function only. I think they're more sophisticated now in handling, but certainly if your employee is treated somewhere with for health care, you're under your plan that's self-insured, that's a covered entity. The plan is a covered entity, and you've got to be very careful with those records. I hope I put that in English.
Yes, good point.
Okay. I guess this is an addition to the previous question. What about vaccination status?
In part, that's going to be covered by state law. In part, because there's a Medicare Medicaid mandate that has been upheld by the Supreme Court as a compliance as a condition of participation requirement. There are ways that you have to provide that. I forget what they are. I forget how the feds have set that up, but for states, the state and federal government have their own rules on that, but it's for compliance purposes. So there are ways in which you have to get that information and have that available. If you're a Medicare Medicaid provider, or if you're in a state that has a separate vaccination mandate. So it would be an exception to HIPAA under those circumstances.
Great questions. Those were all the questions we had submitted during the presentation. So I guess that concludes today's webinar. It was a plethora of information.
We just want to thank everyone for attending, and as I said, either you can call Lyles Parker to talk to either Regina or I or any of our attorneys. If you've got any questions, and again, thank you for attending. Regina, any final words?
No, just thank you. It was a pleasure joining with you, Michael, and speaking to our attendees today. And certainly we're available for any questions or further assistance.
All right.
Yeah, and you'll be getting, and they'll have a copy of the slides, correct, Liz?
Yeah, we will share copies of the slides with everybody who joined today. They'll go out later today, I believe. Okay. Well, thank you guys. Thank you, Regina. Thank you, Michael. And tune in next month to our webinar Wednesday. Bye-bye.
Bye-bye. everyone.
Bye.